about to enter another dementia. A dementia not only of sight and sound, but of mind. A journey into a wondrous land of pandemic imagination, historically associated with confusion, fear, and despair. But where the true believer may yet find feelings of efficacy and empowerment. Next stop, the novel coronavirus zone. Meet Norman. That is not his real name, but his friends call him Norman. Norman Oliver. And if you are wearing a facial covering to prevent the spread of a disease, or considering a vaccination, or have a closed school, business, or church, you are at least familiar with Norman's work in what has become the new normal in Virginia. And if you don't know Norman, you are not alone, because even most Republican leaders and even candidates for office who claim to complain about losing liberty and wearing masks have no idea who this nondescript gentleman is, operating invisibly behind the scenes, almost like a great eminence with awesome powers to change every aspect of your life, and nobody even knows that he exists. Some don't even know his name. But Norman is the State Health Commissioner for the Virginia Department of Health. And on February 7th, 2020, Norman is credited with issuing the declaration of a communicable disease of public health threat for a novel coronavirus that had yet to find its first case of infection in the Commonwealth of Virginia. An unconstitutional law that not even one Republican leader in Richmond questioned. Not even Amanda Chase. They did not even question when it was discovered, under threat of contempt of court, that he had concealed the fact that he had attended a college and graduated from a college that required no college entrance exam. But according to one news report, last March, as the pandemic was beginning, Norm has been an essential part of the pandemic task force that supports Governor Northam's orders increasing shutdowns of schools, business, and public and private concerns in a bid to block the spread of coronavirus. He joined the governor on March 12th in issuing a state of emergency as the number of cases in the Commonwealth began to grow exponentially, and praising Norm's prompt, proactive decisiveness. According to that news report, on February 7th, a month before the first case of coronavirus was diagnosed in Virginia, Dr. Oliver declared the virus a public health threat. Norm decisively declared a communicable disease of public health threat 1 month before affixing his signature to the declaration. But even the orders he co-signed with the Governor Northam, increasing shutdowns of schools, business and public and private concerns in a bid to block the spread of coronavirus, the orders specifically state that such executive orders declaring a state of emergency may address exceptional circumstances that exist relating to an order of quarantine or an order of isolation concerning a communicable disease of public health threat that is issued by the State Health Commissioner for an affected area of the Commonwealth. By simple logic, Norm could not declare a public health threat in an affected area 1 month before it ever appeared. And you would have thought an attorney might have looked at that and said something. You are about to enter another dementia, a dementia not only of sight and sound, but of mind. A journey into a wondrous land of pandemic imagination, historically associated with confusion, fear, and despair, but where the true believer may yet find feelings of efficacy and empowerment. Next stop, the novel coronavirus zone. Meet Marcus Neff. Marcus was a non-resident of Oregon who had claimed a right to certain property under a patent issued to him by the United States on March 19, 1866, a long time ago, far, far away. Marcus brought a famous action in court against a certain Sylvester Penoya, who had claimed title by virtue of a county sheriff's sale after a judgment had been issued against Neff, the non-resident, rendered February 19, 1866, by the Circuit Court for the recovery of a tract of land situated in Multnomah County, Oregon, in a suit against a defendant, J.H. Mitchell. Mr. Penoya, a personage familiar to any first-year law student, especially a law student at a prestigious law school, in his answer denied Mr. Neff's title and right to possession, and set up title in himself. Penoya was a local yokel, and Neff was an out-of-towner, so Penoya essentially took Neff's property and claimed it for his own and dared him to try to get it back. By consent of the parties and in pursuance of their written stipulations filed in the case, the cause was tried by the court and a special verdict given, upon which judgment was rendered in favor of Neff, the out-of-towner. And Marcus Neff was again a happy man, having regained his property all the way in Oregon again. But whereupon Penoya sued out of this writ of error. Penoya offered in evidence duly certified copies of the complaint, summons, order for publication of the summons, affidavit of service by publication, and the judgment in that case, and had objected principally because, this is a very technical legalese type of argument, that the judgment that had granted title of the property to Neff arose from what is described as in personam, or personal jurisdiction of the court over the party to the case, but that upon the evidence it had appeared that the jurisdiction had been established without a personal appearance by Mr. Neff. He never came to Oregon, the non-resident, or by service of a summons upon him, rendering the judgment granting title to him null and void. Very interesting legal argument. And any first-year law student is well familiar with the facts of this case, or one would think. But on April 5th, just a week ago, one attorney filed a pleading with the court that claimed he had never heard of this famous case. Robert Bernard McEntee III, not to be confused with his father, Robert Bernard McEntee Jr., a 1979 graduate of the University of Richmond and a 1982 graduate of the University of Toledo Law School, who is his proud father. No, Robert Bernard III is a graduate of William and Mary College, a 2010 inductee into the Ada Rho chapter of Pi Sigma Alpha, the National Political Science Honor Society at the College of William and Mary. Robert Bernard Jr. is probably very proud of young Robert Bernard III, because after graduating from William and Mary College, a very, very good school in Virginia, he pursued a law degree at Cornell University, received a public interest scholarship there in 2014. And upon graduating from that prestigious law school, Robert Bernard III returned to Virginia, where he was admitted to the bar in 2015, just before the 2016 elections, and took a great high-profile job as an assistant attorney general, quite often even representing the Virginia Bar Association in disciplinary matters against members of the bar. A lot of power. And perhaps power leads to amnesia because the facts in the U.S. Supreme Court case of Penoya v. Neff are practically Sesame Street simple, just like its rule of law. To simplify and for review, the argument of Penoya was that Neff, a non-resident, like a novel coronavirus, when Norm declared a communicable disease a public health threat, did not own property in Oregon because the circuit court that granted the judgment in his favor lacked the power of personal jurisdiction over him to so be able to grant that claim of right to him. For any first-year law student in a course on civil procedure, the case of Penoya v. Neff is essentially an introduction to the topic of personal jurisdiction, but also the notion of what is often described as our rights to due process in court. And in that famous case, the United States Supreme Court, quoting a prior decision in Happy v. Mosher, stated, "An approved definition of due process of law is law in its regular administration through the courts of justice. It need not be a legal proceeding according to the course of the common law, neither must there be personal notice to the party whose property is in question. It is sufficient if a kind of notice is provided by which it is reasonably probable that the party proceeded against will be apprised of what is going on against them, and opportunity afforded him to defend." And lawyers often call this constructive notice. And in that case, the Supreme Court decided in 1878 that it was of the opinion that if reasonable notice be given with an opportunity to defend when appearance is made, the question of power will be fully satisfied. That was the United States Supreme Court. But Robert McEntee III never heard of that case. And in 1945, another case every first-year law student knows, with the advance of industry and the expanding influence of multi-state corporations, the Supreme Court revisited this rule in the case of International Shoe v. State of Washington, stating that due process requires only that in order to subject a defendant to a judgment in personam, if he be not present within the territory of the forum, he have certain minimum contacts with it, such that the maintenance of suit does not offend traditional notions of fair play and substantial justice. So perhaps the question is whether Robert Bernard Jr. might agree with Robert Bernard III that it would accord with traditional notions of fair play and substantial justice to file a motion to dismiss an action by attempting to persuade the court that, as he claims, the gravamen of his complaint appears to be the allegation that Governor Northam's declaration of public health emergency curtailed his ability to campaign for the United States House of Representatives. And since it is now 2021, that matter is, as attorneys say, moot as law. Would Robert Bernard Jr. agree with Robert Bernard III that it is fair play and substantial justice, and not presenting a fraud upon the court by denying that the plaintiff in the case made multiple attempts, both prior and during the litigation, to make contact with the Board of Elections, about which he is only willing to speak, and their attorneys, and had even coordinated with the boards of elections in New Jersey to permit the Commonwealth of Virginia to arrange a software sharing agreement so that they might be able to complete their candidate petition process safely online, avoiding the pandemic, but was ignored. Would Robert Bernard Jr. agree with Robert Bernard III that it is in accord with traditional notions of fair play and substantial justice to wait for a year to tell the court that it needs to dismiss a case when he has not yet corrected the declaration of a communicable disease that had been declared too early and had invalidated the entire pandemic response, from lockdowns to facial coverings? And would Robert Bernard McEntee III be proud to report to the Ada Road chapter of Pi Sigma Alpha, the National Political Science Honor Society of the College of William and Mary, that he had filed a pleading with the court to claim that he did not receive notice, just like in a case of Penoyer v. Ness, that any first-year law student knows, and he only graduated from law school in 2015. And would his distinguished law school alma mater at Cornell University be very proud to know that the only reason that he was claiming that he was never served with a summons was because he had been evading the sheriff in contempt of court? A misdemeanor, an obstruction of justice, a felony punishable by up to 20 years in prison, a conspiracy to violate civil rights, and a predicate offense for establishing a pattern of racketeering activity under the RICO Act? Did he forget, or did they not teach him a right to remain silent at Cornell University Law School? And so here is the truth. My name is Major Mike Webb, and by God, I am running for governor of Virginia. I ask every Virginian and every American true to, like the motto of the infantry, follow me, and we shall overcome. Honest. And y'all go back now. Here. This advertisement was authorized by Mike Webb. And y'all come back now. Here.